Been a lot of reaction to today's decision from survivors of the attacks, law enforcement officials, and lawmakers. It's a complicated case.
And to help us break it down, NECN legal analyst Michael Coyne, who is also the Associate Dean at the Mass School of Law. Good to see you, Michael. You followed the Whitey Bulger case over the summer, watching this case very closely. How will the Attorney General's decision change this case going forward?
I think it changes it potentially in a very significant way. I think now there is an incentive for the defendant to actually plead guilty, to forego his appeals in order to save his life over the next 60 years. So I could see where that would change things significantly. Absent that, he had no alternative but to actually try the case.
But what about, if that does happen, if a plea agreement is worked out, what about the victims in this? There are people who want to have their say in court, want to speak directly to the judge about that suspect, about that defendant. Will they lose their chance to do that?
No, the victims would still have an opportunity to be heard prior to sentencing. There'd be a probation report which would get some input from the victims, but victims would also have still a chance to be heard with respect to the specific sentencing that would be imposed upon him prior to that sentence being imposed.
And you'd think that the government would want that to happen so that emotionally in the community this would play out in court. But aside from that, what other benefit is there for the government to plead out this case? I mean, wouldn't they want to pursue a case like this for a deterrent effect, to make a statement against this guy for allegedly planning and executing a terrorist attack?
The real advantage to the plea would be to forego years and years of expensive appeals and more pain for the victims. Because the fact is that our appellate process is very slow. We will be paying for that entire process, the people, and if there's a plea, he would spend the next 60 years in prison. And, you know, for many people, that would be at least as harsh as receiving the death penalty. The death penalty in this case, some would argue, would be too quick a death for someone who has committed these types of crimes.
Michael, let's break down the language and the statements that we received from Eric Holder and Carmen Ortiz. I remember in Carmen Ortiz's statement, she talked about betrayal against the United States. Was there a reason she spoke in that type of way when it comes to this case?
Yes, that's one of the aggravating factors that are listed under the federal statutory scheme for when the federal government can seek imposition of the death penalty. It is very rare with this administration that they would in fact seek the death penalty. They haven't sought it very often. And in this case, there are about 15 different factors that all say that the death penalty should be imposed, including acts of terrorism, mass murdering, vulnerable victims, police officer killed in the line of duty. If this isn't the case that would justify at least an attempt to impose the death penalty, there really isn't one.
All right, legal arguments and issues aside, do you think there was any political motivation for the Attorney General to seek the death penalty, given that this is a president who doesn't probably want to be seen as being soft on terrorism and has midterm elections coming up?
Yeah, well, but this is an impossible situation almost not to impose it. But if anything, this administration has consistently opposed the death penalty and used it very rarely. But again, this is the classic situation where there's so many aggravating factors. I think the politics did play some role, because I think the public would be outraged if we weren't trying to impose the death penalty with this terrorist.
NECN legal analyst Michael Coyne from the Mass School of Law. Thanks for being here, Michael. I appreciate it.
Thanks.